Hi everyone, this is Hamida. Welcome to Safi Law channel. Today's topic it is relating to bona vacantia and doctrine of escheat. So these doctrine of escheat and the bona vacantia it is relating to the property. So first we try to understand about the property means what, why that, what is the connection to the escheat and the bona vacantia. First, we try to understand about the property. Property, it is a Latin term which proprius or propriated. Proprius or the propriated, which means the things which owned. Thing in the sense what? Thing means either it may be a movable property or immobile property. Thing means whether it may be a movable or immobile property. For these movable or immobile property have some ownership, means for every property they have some ownership, that is called the property. Now for every property we have the ownership, we know that, but few of the property they don't have any means that particular land have no owners to the particular land, or they don't have any legal heirs. So such a kind of lands acquired by the government, this is comes under the escheat and the bona vacantia. Now we will go to the doctrine of escheat. Escheat, first we will go with the example. Then we'll discuss about the definition of the escheat. Here two people are there. Okay, A and B. Both died in the accident. Okay, both died in the accident. They don't have any legal heirs. Even they didn't make any will. They don't have any legal heirs. Even they didn't make any will. In that situation, what the government will do? So the government will occupy to those lands and they can use for that government purpose. Okay, so means the legal heirs, the deceased person not having any legal heirs, at the deceased person not make any will. In such situation, whatever the lands are there, those land acquired by the government, this comes under the escheat. Now, going to the definition of that, escheat means any property the owner of which dies intestate and without leaving legal heirs. Intestate in the sense what? Bequeath of that property, in the sense it is comes under the will. If they didn't make any will, or the person means the deceased person not having any legal heirs, at that situation it comes under means the escheat in the sense what? Not having any legal heirs or not made any will. It is the definition of escheat. Such escheat land acquired by the government. Right. So escheat refers to the right of a government to take ownership of estate, assets or unclaimed property. So those assets occupied by the government and whatever the properties are comes under the unclaimed property acquired by the government. Okay. Now we will go to the term of the escheat. The term escheat derived from the French word esquire, which signifies to happen. When it happened, when that not having any legal heirs, when that not made any will, at that situation, what will be happen? The government acquire the land. This will be happen. That's the meaning of escheat. Now we will go to the doctrine of escheat was not unknown to the India. This actually this escheat it comes from the English term, Latin term. It means these all are the terminologies we received from the common law, that is the English law. But this is not the new for India. This is old. These terms like escheat or the bona fide, old for the Indian, whatever they already they used in various books and various verses, various eminent people. Okay, so here this escheat was used by the Manu in the book of Manu Samhita in the chapter 9, verse 189. So here Manu who used in his book Manu Samhita, in Manu Samhita, who used one of the quotation, in that quotation described about the escheat. What he described, what that quotation he used it? Aharajyam, Aharajyam, ब्राह्मण द्रव्यम राजना नित्यमिति स्थिति इतरेषांतु वर्णनामं सर्वभावे हारनृप. What is the meaning of this what is Sanskrit terminology actually? So this means that the king has a right to all the property belonging to the person who died without leaving any heir, but the king had no right to brahminical property even on the failure of all the heirs. So here the king in the sense what, generally nowadays we are using like a government in the king. Okay, so the king have such a right to occupy to those land who are not having any legal heirs. These things already described by the Manu in his book, Manu Samhita book. Okay, even one of the thing also is described in that in this book, that is brahminical property on the failure of the legal head. This one not they cannot occupied by the government. So the government cannot acquire those land which relating to the Brahmins. Means other lands, whatever the land, it's relating to the others. If they don't have any legal hits, they don't have any. If they may not making any of the will, in such situation, the government acquire to those land. These things described by the Manu. That's why this eschat is not new for India. Okay. Now we will go to the what is the bona vacantia. Bona vacantia includes any property situated in the state of which there is no rightful owner, but does not include an escheat or any movable property found in a public place. First thing, bona vacantia. Vacantia in the sense what? Vacant. Vacant land. Vacantia in the sense what? Vacant land. For that vacant land, bona fide owner, who is that bona fide owner? They actually vacant land, not having any owners, not having any legal heirs, means not having any owners. We don't know about that particular land owner. This vacant area. Who is the bona fide owner? The government is the bona fide owner. Means vacantia in the sense the vacant land, bona fide of that particular land, means that the land is bona fide by the government. Okay, so this is not connecting to the escheat, it is not connecting to any movable property which found in a public places. So here escheat means what? This is owners. Actually, in the escheat, owners are there, but they died, but they don't have any legal heirs, but they don't make any will. This is comes under the escheat. Whereas comes to the bona vacantia in this is what? We don't know about the owners of the land. It's a vacant land. Okay, vacant land and acquired by the government, and that government only the bona fide owner of such a land, that is comes under the bona vacantia. Okay, now we will go to the Hindu Succession Act 1956 section 29 and 30. So here 29 it is described about the escheat only, means when that property it goes to the government, when the government can occupies, means when who are comes under the legal heirs, those things described in the section 29 and the 30. So here section 29 and 30 they describe about the will. If they don't make any will by the deceased person, if the deceased were not they didn't make any will, and also not having any classes of legal heirs, then that property which goes to the government, right? If the deceased person didn't make any will, or this deceased person not having any classes of legal heirs, then that particular property which goes to the government, means the government can enjoy the property and the government is the owner of such property. Now, first we will try to understand about the, according to section 29 and the 30 of the Hindu Succession Act 1956, here we have the various classes of legal heirs are there. Here, class 1 legal, if the first, they will see about the, if the class 1 legal heirs are there or not. Class 1 legal heirs in the sense what? Son, daughter, mother. So these people comes under the class 1. Then again they will go to the class 2 legal heirs are there or not. Class 2 legal heirs in the sense what? Their children, whether they have the children or not, whether it's like sons, daughter. So these are daughters, sons. These secondary group of legal heirs have they have or not. Then again they will see about the agnate class of legal heirs, agnate and cognate. Agnate and cognate class of legal heirs in the sense, agnate it is connecting to the father side relatives. Father side relatives in the father's brother, father's sister. So these relatives are there or not. even mother side relatives, in the sense cognate relatives, means like mother's sister, mother's brother. So these relatives are there or not, where when we are deciding about that particular land, whether it goes to the government or not. First, they will check all the legal heads. What kind of how many types of legal heads, means according to that section 29 and the 30, means class 1, class 2, agnate, cognate, all the four classes, four cases of the legal heads not there to that particular land, not have that particular land, then that the court will decide this land which goes to the government. Is it clear? So this much process is there. It is not the simple way to acquire the land and enjoying to the property. It's not the simple way. So they will check about whether they will have that legal heir or not. So again, not only in the Hindu Succession Act, they have to be check about the particular related lands, like constitution. Again, according to the Article 296, along with that particular local areas, particular acts, if it is related to Andhra Pradesh, if it is related to different areas, different acts are there. As per those acts also, they will follow and they will decide it whether those land comes under the escheat and bona vacantia land or not. Means then only they will decide. Now we'll go to the one of the acts. So it's relating to the AP related act. That is the yeah, it's relating to the, first we will going to discuss about this related different acts. First we go with the one of the case law, that is the Radha Krishnan Singh versus state of Bihar. Radha Krishnan Singh versus state of Bihar, it's happened in the year of 1983. The Supreme Court held that section 29 comes into the operation only on there being a failure of heads, on there being a failure of heads. So I just now said, if all that four classes of legal aids not there, then only the government can enjoy. Same like that here in the Radha Krishnan Singh versus state of Bihar also, the Supreme Court declared discussed about that section 29 comes into the operation only on there being a failure of heads. You see, all the four classes of the legal aids failed, means not having, then only this property which goes to the government. Okay, so now we'll go to the article 296. Even in the article 296 also, they discussed about the Indian constitution, article 296 of the Indian constitution. Whatever that means, this actually after the independence, not only the after the independence, before the independence also, we had that many of the lands are there. So those lands enjoyed by the majesty and few of the rulers and few of the kings. So if that particular vacant land, or if whatever the land no, means we didn't know about the particular legal heads, such land enjoyed by the majesty and the rulers. Same like that, it is connecting to that majesty in the sense what? Union of India. Rulers in the sense wherever the rulers ruled in particular area. Here, wherever the state, it's relating to particular land, the states can enjoy to those land. Generally, what is the meaning of this sentence according to the article 296? Means wherever the land located, suppose if it's located in the particular it's a particular jurisdiction, particular area, this is a particular Hyderabad area, or the any Andhra Pradesh area, or any UP area, or whatever it may be, it's related to particular area wherever it's situated, if a particular jurisdiction, those local authority can enjoy the property, can acquire the land. So this one means majesty in the sense Union of India, rulers in the sense the state authority. This is the state authority, how they enjoyed previously before the constitution amendment of the Constitution of India, how they enjoyed, same like that. After that also, if it is relating to the majesty, now the Union of India can enjoy. If it's relating to rulers, then now it's the state government can enjoy to those property. So these things described in the article 296. Okay, so bona vacantia, this one also the definition many according to the different acts, and as per the Andhra Pradesh Escheat and Bona Vacantia Act, the Section 2, Clause 1, Clause 4, these things, this definition which has described Bona Vacantia as a vacant land. Okay, now we'll go to the AP Escheat and Bona Vacantia Act 1974. We'll discuss it. So Section 2, Clause 1 is describe about the Bona Vacantia. Section 2, Clause 4, Clause 1 and Clause 4 describe about the escheat and Bona Vacantia. Means definition parts, means in the Section 2, all the definition parts mentioned. Like what is the definition of the local authority, who means who will comes in the local authority, and court means what, and all the definition which has described in the particular AP Escheat and Bona Vacantia Act 1974. In generally, when we discuss about the salient features of the AP Escheat and Bona Vacantia Act, here 5 chapters are there, and that 5 chapters described in the 17 sections. Okay, just I go with the brief discussion about the particular this act. Here in the section 19, first, whatever the land, if they know about that it's relating to the Bona Vacantia as well as it is related to the escheat land, first they do the inquiry. The government, the public authority who do the inquiry about the particular land. After the inquiry, they publish, I mean, they put the notification, whether it means the newspaper or any like in the local authority, like if it is related to village area by beating of the drum or something. So what they try to means they have some information relating to particular property to the public. Means what, whether this property belongs, if the legal heirs will come, if they have any legal heirs, then come and occupy to those land. Means these news which gives to the public, right? After that, 3 months, means they will put the 3 months. If they have, that means if the within the 3 months, if the legal heirs will not come, then this case file into the court. And then if any legal heirs will come, suppose if the legal heirs, any of the legal heirs will come, and they have a right to file a suit in the court, then the court will decide it. These legal heirs is a true owner of such a land or not. These legal heirs really the legal heirs of that particular land owner of the legal heirs or not. So the court will decide. After the declaration, if particular related land it is the connecting to the that legal heirs of the particular land, then that property which goes to those legal heirs, or else it goes to the government. Okay, then still 12 years the government will hand over to these land, and whatever the rights and liability, the government only will do it. So this is the complete process for doing of that the particular land, whether it may be a escheat or the Bona Vacantia. They will wait for the 12 years. Later on they will decide it whether this land can sell or not. If they want to sell these land, again they will put into the auction. If whatever the money it will come, which goes to the government's authority. So these all are the criteria which has described in the Andhra Pradesh Escheat and Bona Vacantia Act in 1974. Not only this act, in different areas they have the different acts are that's relating to these particular lands. Okay, so this is about the escheat and the Bona Vacantia. In the next class, we'll try to discuss about the dominant, eminent domain. The many of the related topics is relating to land laws. It's relating to the property related laws. We will property related cases. We will discuss in the next classes. Thank you.